Welcome to Employment Law This Week. I'm George Whipple. The federal government is ramping up enforcement against private employers over what it says are illegal diversity, equity, and inclusion programs. Epstein, Becker, Green's Susan Gross-Shalinsky describes some of the new developments at the EEOC.
The EEOC chair has been on social media, inviting white males who feel victimized by their employers' DEI-related practices to reach out to the EEOC with their stories and to potentially file complaints. The EEOC is also using commissioner's charges as well as information subpoena power to target large companies' DEI-related policies and practices, saying that such practices amount to systemic race discrimination against white employees. The industries involved include financial services and retail, and this is in addition to law firms which had been targeted in early 2025. The EEOC is not the only agency active here. The Federal Trade Commission is taking up the torch as well.
Last month, the FTC sent warning letters to 40 law firms critical of their hiring practices. We asked Susan how clients should respond to enforcement action around DEI.
A lot of the advice that we've been providing to our clients around this area remain applicable. In particular, although the EEOC has stated that certain content in anti-harassment training could constitute illegal DEI, regular anti-harassment training and anti-discrimination policies that are consistently applied remain important. Aside from reviewing policies and procedures, employers should be especially mindful of external communications and information available on the company's website, such as annual reports, press releases, and communications around both internal and external programming, since governmental agencies have reviewed such content in connection with their enforcement actions.
The Justice Department is also focused on DEI, pursuing a novel approach to False Claims Act liability for private employers that receive government funds. Epstein, Becker, Green's Daniela Lee has more on that.
The FCA, which was enacted during the Civil War to prevent fraud in the government, is often used today to investigate, penalize, and deter allegedly false claims for payment. But DOJ is now embracing a broader and entirely novel theory that continuing certain DEI practices while holding a federal contract or receiving federal funds can be framed as fraud against the United States. In False Claims Act investigations, DOJ can be expected to look past the labels and focus on whether a program allocates benefits or burdens based on protected characteristics. This is just another reason for private sector employers contracting with the government or seeking government funds to remain meticulous in reviewing the terms and conditions of those contracts and in reviewing their DEI programs.
Thanks, Daniela and Susan, and thank you very much for watching. We'll see you next time.